Everyone. Good afternoon, Mr. Hill. Thank you for being here with us today. I would like to start then reading Mr. Sill's curriculum. Mark Hill is a barrister specialist in ecclesiastical law and religious liberty. He has represented clients in the UK Supreme Court and the European Court of Human Rights. He holds judicial appointments in the civil and ecclesiastical courts. He is a lecturer at the Law School of Open University and is a visiting professor at Cardiff University's Center of Law and Religion at the University of Pretoria in South Africa, at Notre Dame University, Sydney, and at Dickson Poon School of Law at King's College London. He's a fellow of the Center for the Study of Law and Religion at Emory University. Publications include the Routledge Handbook on Freedom of Religion and Belief, Christianity and Criminal Law, Great Christian Jurists in English History, Magna Carta and Religion and Rule of Law, Religion and Law in the United Kingdom, Religion and Discrimination Law in the European Union. He's a consultant editor of the Ecclesiastical Law Journal and a member of the editorial boards of the Oxford Journal of the Law and Religion and the Revista Geral de Direito Canônico e Direito Eclesiástico del Estado. He is a former president of the European Consortium for Church and State Research. He's the vice president of the International Consortium for Law and Religion Studies.
Mark will deliver a lecture on the accommodation of religion in the workplace, dignity and productivity. Thank you very much, Mark. The floor is yours.
Thank you very much. I would like to pretend that when Luma read those credentials so well, I was embarrassed, but I wasn't. I was thoroughly enjoying it. So thank you very much. Rodrigo, thank you for your invitation. It's lovely to be here, but it's not quite as nice as being in Uberlandia. And I have so many happy memories of being there. So thank you for making me part of this day with the opportunity to listen to friends and to get to know some new young scholars. Now, I think there should be some PowerPoint slides that might help us get through the next few minutes. And if those can be made available, then we can be underway.
Sarah, the PowerPoints, please, or Luma.
Here we are. It's lovely to be here. Let's move on to the next one. This says a little bit about what I'm going to address, because Rodrigo asked me to focus on sustainable development goals, and in particular, the work of the G20 in relation to that, and the Interfaith Forum also related to that. And it very much put me in mind of a substantial meeting in 2018 when this subject was addressed, and it seemed the ideal topic to take this evening. Next slide, please. But my memories of 2018 are very much of a dear friend, Juan Martin Vives, who may be known to many of you who are listening to this lecture. Distinguished Argentinian expert in law and religion, who was part of the process which I'm going to speak about in the next half hour or so. His presence was a huge part of the success of the venture. He is a young man on the cusp of a great career as a scholar and expert in law and religion, and his loss is a great sadness to this community. And if you'll allow me, please, to dedicate this evening's lecture to the memory of Juan Martin Vives, and to remember in our thoughts this evening his beloved wife and his two gorgeous children. Next slide, please. So, taking these next images quite swiftly, it brings us immediately to the issue of sustainable development goals. Goals recognized by the G20, largely as part of the economic and political motivation for governmental action. But what I hope to demonstrate this evening is that they have a much broader application, and dealing with certain specifics, they are of significance when dealing with freedom of religion and how we interrelate with one another in the workplace. Next slide. This is beautiful and colorful, but it's hardly legible. What it does show you, in amongst that checkerboard of color, is that what was isolated by the G20 were 17 broad and overlapping sustainable development goals, which have been the focus of attention for the last few years and which will continue to do so. But I think two of them in particular have relevance to those of us working today in the field of law and religion. Next slide. The first of those is numbered 8, and as the image of the factory with a roof pointing to greater productivity is concerned, the topic is decent work and economic growth. Those are laudable objectives for states across the globe. Next slide. But related to that is number 16. And number 16 speaks very clearly, as the image shows, of peace and justice and strong institutions. And when it talks of strong institutions, this isn't merely about central government. It's about all levels of regional and local government as well, and how collectively they can contribute to growth, prosperity in this way. Next slide. Again, it's a rather poor visual image, but it takes us back to September of 2018, when many of us met in Argentina for the G20 Interfaith Forum. And at the express invitation of the government of Argentina, the focus of that G20 meeting and of the Interfaith Forum was dealing with how religion, freedom of religion, and religious liberty interrelate with the Sustainable Development Goals that I've already spoken of. Next slide. And I was given charge of a work stream within that meeting in 2018, dealing with dignified work. And you'll see listed in front of you the individuals who were at the core of that particular work stream looking at dignified work. Carlos Costa, well respected for his labor law work. Richard Fulton, a US scholar who's done an enormous amount of work in the field of religious freedom. Myself and dear Juan Martin, whom I've mentioned already. Not on the slide, but an important part of the success of our work was the British ambassador to Argentina, His Excellency Mark Kent. And although he played no part in our deliberations, he provided a sumptuous dinner at his residence in Buenos Aires. And it was the convivial working environment that made the work we were doing particularly successful. Next slide. And I've mentioned the work stream in which I was involved, focusing on dignified work. But at the same time, this large international conference had other work streams, some of which bisected with what we were doing. One was on religion and anti-discrimination norms, and the other was on innovation and why religious voices matter. And the purpose of what we were doing in our separate ways was to produce recommendations which could then be endorsed by the G20 Interfaith Forum and put forward as serious recommendations, not merely to the governments of the members of the G20, but more widely as international norms to assist in the years ahead. Next slide. And so what was the presenting issue at the time of our meeting that we needed to address? Now, the first issue, I think, was the idea that religious identity travels with us. Now, I've made mention there of the ecumenical patriarch, and I just want to go quickly to the next slide, and then we'll come back here, because there's a beautiful quotation from His All Holiness Bartholomew I, the ecumenical patriarch of Constantinople, a man revered for his canonical study, for his leadership within the Orthodox community, but in particular for being a very early proponent of the importance of combating climate change. But what the patriarch wrote was this: faith is not a garment to be slipped on and off. It is a quality of the human spirit from which it is inseparable. In other words, our religious identity cannot be divorced from our other identity. We are functioning human beings, and our faith is part and parcel of that functioning nature. Let's go back, please, to the previous slide. And the importance of religious identity is that it's not something that is only exhibited within the privacy of the home or when attending a place of worship. It is a 24/7 permanent part of our identity. And we did some work calculating the percentage of our time that we spend in offices or factories or other places of work. And often when the calculation is done, people spend more time at their place of work than they do with their family or elsewhere. And a workforce that considers itself to be respected, which is afforded dignity by the employer and by society more generally, is considered to be a productive workforce. And I will mention briefly towards the end of this presentation the statistical evidence which exists to demonstrate that high levels of religious freedom in particular countries generally correspond with high levels of economic activity and productivity. Division, argument, unhappiness, and dissent, these all have the potential to compromise the effectiveness of any business or organization. And what's meant by that is there is a vested interest in employers to ensure that their staff are contented. And a high priority in the grounds of contentment concerns religious identity and the capacity for religious manifestation to be acceptable within the workplace. And a denial of accommodation of religious views, religious sensibilities, and religious manifestations is in itself a form of religious discrimination. Next slide, and then the one after that. Now, when we were meeting in September of 2018, the idea of COVID was unimaginable. We didn't for a moment consider that within 2 years of us starting our work, there would be a global pandemic that would result in many workplaces being closed and the requirement that people worked from their own homes. And already we're beginning to experience deterioration in mental health because individuals no longer enjoy the sociability of the work environment where they can meet their colleagues, interact with their colleagues, and enjoy the level of collaborative functioning, which is essential to human existence. And I'm sure in years to come, academics will do studies of the lockdown that we've all had in our various countries and how a significant factor in the negative outcomes from that lockdown has been the denial of individuals of their opportunity to attend their place of work. And so many of us are at the stage now where we're thinking of a return to normality, of returning to our workplaces, picking up where we had left off and going back to where we were 12 or 18 months ago. But I pause there to say, should our objective be to return merely to normality, or should we not be rather more ambitious and build back better? When we return, provide for a better form of accommodation in the workplace and a better form of making provision for the religious sensibilities which each of us enjoys. Next slide. So what are the day-to-day issues faced in a work environment which need to be addressed, particularly from a freedom of religion angle? The first, I think, self-evidently, is non-discriminatory hiring and firing. The right to work, the right not to be dismissed, should not be dependent on one's religious identity. Secondly, religious dress, the extent to which one can be veiled or otherwise at work, the extent to which one's religious clothing can be accommodated by variations with the uniform policy adopted by the employer. And we move through the other items listed in front of you. Dietary requirements, the need for washing and praying at designated times, in designated ways, in particular locations. The accommodation of holy days, which are different depending on one's particular religious affiliation. And then finally on that list, the performance of duties that conflict with religious beliefs and practice. And those familiar with the work of the United States Supreme Court will perhaps have particularly in mind the Hobby Lobby decision and other cases of that type, where the manner in which employees are accommodated with their religious identities was discussed by the court. It may be that these intense cases of litigation deriving from the United States slightly color and distort the broader principles I'm advocating in terms of a global approach to issues of this type. Next slide. So how do we deal with these matters? Not by aggressive legislation or by the intervention of the courts, but on a more casual, low-key basis on the work floor. The first and most important thing to note is that employers need to be religiously literate. It's often the case that employers have no idea what the religious needs may be of a diverse workforce in a plural state. And although the obligation to be religiously literate falls on the employers, it is the employees themselves who must provide the materials in order to educate their employers. Religious illiteracy, in my opinion, is one of the greatest barriers to freedom of religion in the modern world. And that religious illiteracy is something that we see throughout governments at national, local, and regional levels. There is governmental and other guidance, and at the end of this talk, there will be a slide with some hyperlinks that will take you to that guidance. I also make reference to local faith leaders who have an obligation to assist in making known what is required by way of religious practice and observance. And there needs to be a genuine and meaningful engagement between employers on the one hand and employees on the other, in order that there can be a reasonable accommodation of religious beliefs and practices. But again, this is a sliding scale. Nothing is absolute, and employers cannot do everything for everyone. And there needs to be a balance applied in the equation. And one needs to look at there being no undue hardship for the organization and no undue negative impact on fellow employees. It's all very well allowing one individual time off to celebrate his or her holy day, so long as the institution itself doesn't place a heavier burden on other employees who have to cover for that individual's work. Next slide. I'll say a little bit less on this because it's a slightly specialized area, and it's with employers who have a religious ethos. State employers are generally seen as secular. Most multinational industries don't have a religious ethos, but smaller organizations do. And there's a question as to the extent to which accommodations must be made in the employer's favor to have regard to that particular ethos. Churches and similar bodies self-evidently have that religious ethos at their core, but an interesting item for discussion is the extent to which commercial bodies and corporations can themselves have a religious ethos and whether that can similarly be reflected in the way religion is accommodated in the workplace. Next slide. Well, we've got this far into today's talk, and I've said nothing about law. So for a few minutes, forgive me if I descend into the dreadful world of statutory provision and legal regulation. Next slide. I expect you'll be familiar with the overarching principles I'm going to draw from international treaties in the next couple of minutes. You're familiar with the Universal Declaration on Human Rights. Article 18 articulates that everyone has the right to freedom of thought, conscience, and religion. And I've emphasized in red that is to be enjoyed in public or private, returning to the arguments that religion is something for the home or the place of worship. That's not what the Universal Declaration says. The right to freedom of religion is something which exists in the public sphere. It's a right to manifest that religious belief in a number of ways. And the crucial term for our discussions today in relation to the workplace is the question of religious observance in the public sphere, in the place of work. Next slide. And what we find is that same language repeating itself in other international instruments. And here we have the International Covenant on Civil and Political Rights, dating from 1976, Article 18, setting out the right to freedom of thought, conscience, and religion. But Article 18.3 here, introducing the concept of that right not being absolute, but being one which is tempered by reference to certain limiting provisions. And the wording used to express the limitations which can legitimately be imposed on the wide freedom of religion is expressed in this way, as limitations as are prescribed by law and are necessary to protect public safety, order, health, or morals, or the fundamental rights and freedoms of others. So there's a trade-off that needs to be done, but it's one which is done very much from the point of view that the right is the leading force, and the limitations are to be narrowly drawn to the extent to which they impinge upon that overarching right. Next slide. And coming a little closer to home, we come to the familiar language, for me at least, of the European Convention on Human Rights, where the first paragraph of Article 9 sets out the absolutism of the right to freedom of thought, conscience, and religion. And the second part talks about the manifestation of that right being subject to narrow limitations. They must be prescribed by law, necessary in a democratic society. And we see there, once again, the familiar vocabulary of public safety, the protection of public order, health, or morals, or the protection of the rights and freedoms of others. Next slide. So as well as legislation which creates a right to freedom of religion, many countries now have in parallel either equality legislation or anti-discrimination legislation, which forbids private employers and public employers from discriminating amongst their workforce on any of a number of protected characteristics. And these differ from country to country, but I've given examples of some which are significant there. Characteristics of age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, sex, sexual orientation. But right there in the heart of them is religion or belief. So in most countries now, there is a parallel or twin track approach whereby there is a right to freedom of religion and there is a right not to be discriminated against on the grounds of religion. And those two forces, while they are conceptually separate and often have a different legislative source, are incredibly important in affirming, maintaining, and asserting one's religious identity within one's place of work. Next slide. So that was what I've said about law. Now what do I want to say about dignity, the other great concept that's been raised here? Well, next slide. Here we move from Buenos Aires to Punta del Este, a very short geographical distance, but it's one that takes us to a very significant document that was produced in 2018 and takes its name from the city in Uruguay, where the terms of the declaration were agreed. And the date is significant because it's exactly, I think, 70 years from the signing of the Universal Declaration of Human Rights in 1948. And these two documents are very closely related. The Declaration asserts what the rights are, and this document on human dignity gives to us the tools in which we can navigate those rights and enforce them at a grassroots level. And the title, I think, of the book is important. It's a lavishly illustrated brochure in which the Declaration is first set out. But the important thing is this: it's a declaration on human dignity for everyone, everywhere. No one is excluded. No one is left behind. The aim of this document and the aim of the concept that lies behind it is to maximize individual dignity for all people the world over. Next slide. And I've added a brief quote here from the Right Reverend Nicholas Baines, who is the Anglican Bishop of Leeds. And I've included it because it was said very recently at the General Synod of the Church of England, only last month. It's not original. It's been said by many people at many times in the past. But it's important, I think, to bear in mind exactly what is being said and what lies behind this very simple sentence. To only stand up for the rights of Christians, says this Anglican bishop, is an act of self-harm, by which he means that co-religionists, those of other faiths and of no faith, share the same human dignity, share the same human rights, and need to have their rights and their dignity promoted in the same way. And that if a Christian denomination only advocates in favor of freedom of religion for a Christian sect, then it's doing itself no good at all, and it's not promoting the cause. Next slide. So I start by looking at the preamble to the Punta del Este Declaration. And it recalls that in spite of all their differences, nations of the world concurred that the dignity of all people is the basic foundation of human rights. So behind the 1948 Declaration lies this powerful concept of the dignity of all people. And it recalls that human dignity is the wellspring of and underpins all the rights and freedoms recognized in the Universal Declaration as fundamental. So the term may have become lost or obscured in the last 70 years. The Punta del Este Declaration brings that term right back where it deserves to be, in the front and center of discussions of this type. And the preamble continues, recalling that the Declaration has served as the inspiration for an array of international and regional covenants. And of course, that's very true, but it's in interpreting and applying those international religion covenants where the tool of dignity is invaluable, both for employers, employees who have to negotiate with one another, and for judges who, in hard cases that can't be resolved amicably, ultimately have to make a binary choice between one side winning and one side losing. Next slide. So I'm just going to look at a couple of the articles of the Declaration. The first one I'm going to look at is Article 6. And this talks about how one seeks to find common ground. Litigation is adversarial. It pushes people further apart, but seeking common ground is significant. And by focusing on human dignity for everyone, everywhere, will encourage people to search for the ways to find common ground regarding completing claims. And this is important, to move beyond exclusively legal mechanisms for harmonizing, implementing, and mutually vindicating human rights in order to find real and lasting solutions to those conflicts. Next slide. And again, Article 9 continues by referring to respect for the human dignity of everyone, everywhere, supports effective human rights advocacy, recognizing the universal and reciprocal character of human dignity is a corrective to positions claiming rights for some and not for others. And it's so easy, looking at conventional litigation, to see one right being put in opposition to another right in this adversarial manner I've described. But just by tilting the focus slightly and retracting from the view of rights and refocusing on the view of human dignity, what one can do is find a way of maximizing the dignity of all by respecting the rights, but not seeing one as trumping another or as being superior to another in that context. Next slide. So we've looked at the law, we've looked at dignity, and we now come to look at productivity. And I touched on this at the outset. Next slide. Brian Grimm, known to many of you, founding president of the Religious Freedom and Business Forum, was also present at the G20 Interfaith in Buenos Aires and has been one of the principal players behind the G20 Interfaith Forum. And this is what he says: where you have religious freedom in a business, where people are free to bring their whole soul to work, you create stronger teamwork, more investment in the company, more retention, and greater motivation. Now, to be honest, I've been rather skeptical of the assertions made by Brian Grimm over the years, because it seems to be quite a bold assertion to make. But as I've met with him more frequently and read more of the data he uses to underscore his conclusions, there is a real and sustainable body of intellectual work which suggests convincingly that high rates of religious freedom produce high levels of productivity. But I need to move on and I'll say no more. Next slide. So what were our recommendations born out of the work we did back in 2018? Next slide. I'm just going to talk to some of them. Government should promote and facilitate an interactive process. And this is the point. It doesn't come from one side or the other. It takes both sides, employer and employee, properly to engage. And it starts with the employee advising the employer of the need for the accommodation of a religious practice. When that step is completed, the employer must engage in genuine and sympathetic discussion of whether and how such accommodation may be provided. And there is an obligation on the employer to make an affirmative and bona fide effort to provide a reasonable accommodation. So good faith comes into it. It must be a bona fide effort. And then there should be an independent adjudicator or mediator system which could be established if the parties between themselves can't resolve the matter. Next slide. Looking at the accommodation, one mustn't be blinded to the crude economic realities and where undue hardship might fall. And it's important to identify the cost of the accommodation, including any loss of productivity or retraining, and to look at the overall financial resources and the size of the employer relative to the number of employees. So a large multinational can make an accommodation, which a small family firm probably cannot. Everything determined by its own individual facts and circumstances. Next slide. And these continue with the recommendations, looking at issues about religious observance and so on, which shouldn't be compulsory in any way. But I've highlighted particularly 6.6 because this is the coercive force whereby this recommended dignity in the workplace can be rooted in reality. And it's a similar provision that we are seeing more and more in relation, for example, to outlawing human trafficking. And it's the obligation that governments who have enormous buying power with their procurement should not enter into contracts with large-scale employers unless the contracting party can demonstrate that there is a policy in place which complies with the process that was outlined on the previous slide. So this isn't merely wishful thinking. This genuinely has teeth, and the recommendations which we fed back to the G20 governments include a responsibility on their part to withhold commercial contracts from firms and companies which haven't shown a willingness to comply with these particular requirements. Next slide. I said I'd return to a few hyperlinks. I don't intend to take you to them all. These are largely British or American, and they are really significant resources. The first set out how the Equality and Human Rights Commission and the Employment Opportunity Commission works to embed religious freedom as part of the daily diet of employers and employees. And then the second clutch of hyperlinks demonstrate where religious organizations themselves, some Christian, some Jewish, some from elsewhere, are actively putting together their own resources, demonstrating what their doctrines are, and more particularly what the requirements of manifestation are arising from those doctrines, so that they are open and clear about what they require, which enables much better engagement with the employers to whom they are answerable. And those are really important stages in combating this religious illiteracy problem, which I highlighted earlier. I hope these slides can be made available to anyone who wants them, but I think from the next slide, that brings me nicely and contentedly to my conclusion. So thank you all very much for your attention, and a very good evening from London as night begins to fall.
Thank you very much, Mark. We are so happy to listen from you, and also to have both presidents of the most important law and religion scholars in the world here at the session. Ana Maria Celis is also here with us, so we are very honored to have both of you. Regarding the Dignity Declaration, I am including in the chat a link to the declaration in English, Portuguese, which was translated by our team, and also in Spanish, so you can find it. And if anyone has questions, please raise your hand, or you can open your microphone. And okay, Luma, I think you were the first.
Mark, can everybody hear me?
I can hear you perfectly, Luma.
I would like first to thank for this great presentation. I think that was very interesting. And I had the opportunity of reading your work before today. It was also very, very nice and very, a lot of great information for study. And therefore is my question based on that exactly. On the paper, you pointed a little bit about the difference between accommodation being implemented by private and public employers. And I would like to know if you could talk a little bit more about the difference of this application from those two different like sectors. If different at all, how would that be?
Well, I think in the ideal world, they should be no difference whatever, having regard to the nature of the employer, because these obligations apply to everyone. The right to manifest one's religious identity is a right which doesn't depend on the nature of the employment you are in or the employer who is paying your salary. But I think there is a small distinction in that I think one will always place a higher obligation on states which have duties of neutrality, particularly. And one can just about see how small companies with a very limited workforce are less easy to fit in to the model which I've demonstrated. But if you're looking at a large multinational company and a state government, the employer obligations, the duty of fairness, the duty not to discriminate, and the duty to uphold religious freedom should be absolutely identical.
Thank you. Thank you very much.
Thank you. We have time for maybe 2 questions from the floor. I'd just like to mention that Professor Mark's paper on COVID was mentioned recently by the Brazilian Supreme Court by the Justice Rapporteur. So it was a very important decision regarding the restrictions on collective activities of religious communities. So
I was delighted to hear that the Brazilian judges had been referred to my writings.
Yeah.
I just wish the British judges would do me the same compliment.
Do you have questions? Of course, I have a list of questions here, so if you're not asking, I will. But
well, I have another one. If there's
you have another one, okay. But do you have a different person like that would like to ask questions, or
yeah,
can I go back to Luma? No. All right, Luma.
My question is kind of, I think it would be short. It's kind of pretty specific. I was thinking about like how accommodation being implemented in a country like Brazil, in which we have a considerably like vast diversity of minority religions. How could the employer collaborate that these accommodations also don't lead to a certain kind of discrimination by excluding certain religions and only accommodating a few or the majority ones?
Well, part of that question is answered by the non-discrimination legislation, and that if you have a majoritarian religion and you afford to that majority an accommodation, then because you can't discriminate, you have to give a similar accommodation to all other religious bodies. So it's a way of manipulating the right to freedom of religion and the positive duty not to discriminate, and that the two coming together, it's like two rivers merging, and the force of the moving water doubles and redoubles and becomes a very effective tool for lawyers who are seeking to make those assertions. But I also think one needs to have an eye on the reality of the situation, because you talk about multifarious religions as if there are tens of thousands of religions. And indeed, there may very well be in smaller denominations. But if you look at the practical reality of these things, there is so much overlap between one and the other in the question of manifestation and what the accommodation is, that you'll find that you only need to, as it were, 10 or 12 workable accommodations, and you can satisfy several hundred religious organizations, because the factual difference between what one requires and what another one requires, it often reduces to vanishing.
Thank you.
Thank you, Luma. I think Carla, we can accommodate your question to Mark. It seems to me that you have a question.
Okay, so the question is more like for him to talk more about how to promote accommodation when one's religion kind of begins like an inconvenience to third parties, customers, or even the company itself. I think he mentioned it.
Well, I think what you're asking really is where the accommodation is to be found. I think that there can be very little doubt that the employee needs to say what they require, and the employer needs to listen honestly and respectfully and make a significant advance towards meeting that objection. Now, as between one case or another, that will vary considerably. And you're absolutely right. If the practical accommodation to one employee causes immeasurable burden to 10 or 12 employees, then I don't think any rational individual will say that that is a fair resolution, because the employer, as well as being fair to the religious actor in this scenario, must similarly be fair to all of the other employees that there are. And so one would look at that situation and one would try and find the least burdensome route of accommodating that first individual employee. And I think with imagination and goodwill, that can often be found. Frequently one finds employers immediately say, oh, we can't possibly accommodate because the sky will fall in and every employee will be complaining, the workforce will be ungovernable, and it will be a disaster for our business. And that's very often the initial starting point of employers. But when you probe further and you say, well, actually, where is the real difficulty? It becomes fairly readily apparent that the difficulty is less severe than might first be perceived. And I spoke about mediators and trained individuals who over time have developed quite significant ways of engaging with the individuals and coming to a conversation where employees generally can be happy. And I speak as a judge and I speak as a lawyer. The last place you want these problems ending up is in court. You need to keep them out of court at all costs and solve them amicably where there can be room for give and take. Because frankly, once you're asking a judge to decide, then there can only be losers coming out of the situation.
Professor Mark, thank you very much for taking your time to join this international colloquium. It was a great pleasure to have you here with us. Unfortunately, we don't have more time for questions since we have a series of paper presentations starting in 5 minutes. So we have to close this part of the program in order to start the next session. So
well, thank you, Rodrigo. Thank you for your colleagues. It's been a pleasure to be part of your meeting today, and I wish you every success in the remaining part of your program.
Thank you very much. And we hope next year you will travel to Brazil to deliver another lecture.
I shall be on the phone to British Airways as soon as I finish.
Thank you very much. So thank you all the participants, and we invite you to stay in this room for the next and for the last session of this international colloquium. There are several very interesting papers that will be discussed during this part of the program. Professor Raoni, who is going to be the coordinator of this presentations, is already with us since the beginning, actually. And so let's go to our 5-minute break, and then we start with the paper presentations. So you can stay in the room, just close your camera and microphone, please.